Good morning. This is an important judgment in respect of Unlawful Activities Prevention Act, UPA. Unlawful Activities Prevention, and Section 45 to 52, and the rules, recommendations, and the sanction of prosecution rules. Rule 3 and 4, UPA, UAPA, UPA, UPA. See, the problem is the unlawful activities against the state, against the union government. Here, the main thing is so many definition about the grant of sanction, approving the recommended authorities report, and what not, and at what stage you have to prepare or challenge the sanction order, and what stage you can challenge the framing of charge if you have to claim that under section 218 and 224 when there was misjoinder of charges, and all these things have been decided, though this judgment seems to be somewhat tough, but this judgment may be referred by the prosecution authorities or by defense counsels even during a trial for other offences. Therefore, the advocates who are pursuing their examination, assistant public prosecutor and district judges, district municipal judges post, kindly deeply go through the judgment, read it at every page, so that you can understand the minds of the Supreme Court giving ratio decision in respect of grant of sanction and in respect of misjoinder of charges, framing of charges, etc., etc. This is AIR 2024 Supreme Court 4684. AIR 2024 Supreme Court 4684. Puleshwar Gope, Union of India and others. The petition was filed to quash the proceedings, grant of sanction, framing of charges, etc., etc., before the division bench of Jharkhand, and that was rejected. Therefore, they went up to Supreme Court. Supreme Court has given the following ratio decision. Number 1, challenge against the validity of sanction, where will be the appropriate stage. They say it should be at the earliest instance available, not after trial commenced, only to delay the proceedings. Second ratio is there was a timeline for grant of sanction. That timeline fixed for grant of sanction by the by rules is mandatory. The Supreme Court has stated that mandatory because the defense, the accused argument was that the authority has accorded sanction within a short period. Therefore, there may not be an independent application of mind to grant sanction. So, therefore, the Supreme Court has said the 45 section of the UPA Act fixed timeline. That timeline, since it is pertaining to the criminal prosecution, affecting Article 21 for speedy and fair trial, they have held that shall means it's mandatory. So strict construction of penal statute, use of the word shall. Then they say lack of independent review because of short time was not acceptable. That was the other ratio. Then question arises, accused has right to avail all remedies available under law, even including sanction. So at the earliest possible, because trial court has to apply and determine the question for its competence to proceed further, basis on which any other proceedings or appellation would depend on answer to this question. So trial when was under the way, The witness already been examined. No finding could be returned on challenge to the validity of sanction. Therefore, left to raise it before trial court. Then misjoinder of charges is most important. According to him, the other accused who are included as an accused, their transaction is nothing to do with the Pulesh Gope's transaction, and they therefore joint or separate trial is a decision to be taken by the trial court. Liberty to was granted to accused to raise said issue before trial court. That was also remanded back. Then question of companies comes. Here he says he says that when the company was allegedly involved in collecting fund and for terrorism, so the only grounds available for the person who was representing the company that he was not in charge of that company at the relevant time, or that he had made reasonable efforts to prevent commission of offence. Otherwise, he will have no ground to challenge it. Concept of independent review by authority has been deeply discussed in another ratio. All this you kindly go through the entirety of judgment. Best wishes.